This case is involving 3 minor misdemeanor citations, a elimination of license plate, seatbelt violation, and a disorderly conduct charge for recklessly causing inconvenience, annoyance, or alarm by hampering, impeding, or otherwise hindering vehicular, pedestrian, or other traffic on a roadway. Please tell the court the circumstances under which your attention was first drawn to the vehicle operated by Mr. Bri'onte Dunn.
I was traveling southbound on South Arch Avenue in the city of Alliance, County, Ohio, approaching Broadway Street, which is a intersection with a blinking yellow and red light at that time of night. I had the right-of-way with the blinking yellow light. I observed Mr. Dunn's vehicle traveling from the west to the east. It appeared he was going a little bit fast for that intersection that he was coming upon. Upon approaching the intersection, it looked like he wasn't going to be able to stop at the intersection. As I was going through the intersection, I veered to the left and slowed down a little bit because I thought he was going to come through and strike my vehicle. He did go past the clearly marked stop line and also went past the crosswalk, allowing his vehicle to go approximately 3 feet into the streamline of traffic of which I had the right of way.
Officer Rakin, what exactly did Mr. Dunn do that was disorderly?
He hampered and impeded my lane of traffic.
Not legal terms, tell me what he did.
Well, he almost struck me with his vehicle.
How many other people have you ever charged in the city of Alliance for almost striking your vehicle with disorderly conduct?
We got in the car. Within 5 minutes of driving, he was going pretty fast and there was flashing lights, and it wasn't one of those yellow ones, it was a red one. So I yelled at him, I was like, you need to slow down. And he was speeding, and like we didn't pass the white line, but a cop passed by. And so we turned left and we're driving, and the cop turned around and pulled us over.
I'll give you a traffic ticket for the license plate light and a seatbelt.
Yes.
Is that fair to say?
Yes.
I watched you on the tape. Did you ever argue with anybody there?
No.
Did you ever raise your voice?
No.
Okay. Do you feel like that you caused anybody to have to go out of their way?
No.
Did you almost hit that police car when he was coming through the yellow light and the red light? Did you feel like you almost hit him?
No.
On the video, did you see anybody make any big turns or anything like that when they went through that intersection?
No.
Did you hear the officer say anything on the mic, oh my God, this guy almost hit me or something like that?
No.
When that happened?
No.
He turned around at that point, did you see that?
Yes.
And he pulled you, see the lights come on in the cruiser?
Yes.
What'd you do then?
I pulled over.
And you pull over the side of the road?
Yes.
Pulled over properly? He make any issues about that you didn't pull over properly?
No.
I don't believe the state has proven all the factors of disorderly conduct in any way, shape, or form that would show that my client has done anything under the 4th, Madden 84s, with the prosecutor saying to hinder or prevent the movement of persons on a public street, road, highway, right of way. It just has been proven, Your Honor, that elements are insufficient at this point to even proceed to our case at this point.
The unquestionable facts before the court is that Bri'onte Dunn operated a motor vehicle at a flashing red light, came through the stop block into the intersection, and nearly caused an accident. That alone hampered, impeded, caused inconvenience, annoyance, and alarm to the police officer driving the car. At that point in time, he's just a person driving a motor vehicle. The fact he happens to be a cop doesn't exclude him from the protections in the ORC. An individual passing beyond the stop block, beyond the crosswalk, and nearly striking a police cruiser. That's what caused the cruiser to turn around. Officer Reagan turns around, he effects a traffic stop. He flat out tells them, within the first few moments of approaching, you know why I pulled you over? You came through the flashing red lights and nearly struck the car. That alone is sufficient. Now, whether it's an often used charge or not doesn't make a difference. I know Mr. O'Byrne likes to say, hey, it's not commonly used, but the charge exists. And if the elements of the crime fit, the charge may be properly applied, and it does apply in this case. An act that was taken, there's no lawful purpose to drive into an intersection, nearly striking an oncoming vehicle. The officer does have the ability.
They wanted to make it into disorderly conduct. Now they're trying to stuff the facts after the fact back in and say that Bri'onte had somehow impeded traffic. There's no witnesses here. The 12 or 14 cars that went by, not one of them came in to complain about that they were hindered at all. The only car that stopped was a car that was an undercover officer is the only person that stopped her in a marked cruiser. That is the only person that stopped. Didn't interfere with the rights of any others, because we don't have any others here to testify that he did. The only third party that came was Donna Hatcher, and she came, and nobody asked her whether she felt that she was hindered at all by this conduct. If this is the case, Your Honor, in this charge, then everyone that gets pulled over, gets in a traffic accident, gets pulled over for speeding, or doesn't have the registration on them at that point, or doesn't have the license on them at that point, is hindering or preventing the movement of persons on public street by others. They should all be charged with disorderly conduct.
Based upon the evidence presented and without anything presented to the contrary, I will find you guilty of no rear license plate light. I will also find you guilty on no seatbelt, since you admitted you didn't have a seatbelt. If you say that a person is committing disorderly conduct every time that an officer is required to investigate a situation, especially a situation involving a vehicle, it would be unrealistic to believe that that's what that statute is meant for. That's the officer's job. You don't have any evidence before this court of anybody other than the officer doing his job being hindered or impeded. And based upon the case law that I have seen and the evidence before me, I'm going to find you not guilty of the disorderly conduct. And seatbelt, finding is guilty, $30 in court costs, and the rear license plate illumination, finding it guilty. $30 in court costs, I will give you credit on the fine if you bring me a proof that you fixed your mother's rear license.